Good morning, Liz.
Morning, Michael.
So today's the big day when we get to announce our top 5 trust cases of the last year.
Yes.
We've been anxiously considering our long list and whittling it down to our short list, and we've been considering all aspects of these cases, and I think we've now finally got to a position where we can announce the winners.
Yes.
Right.
Why don't you start?
Let's get on with it then. Yes. So the first case is from Guernsey. It's Rosnano Capital and Mollard International. And that was a case about Section 53 of the Jersey Trust Law, which said that where all of the beneficiaries are in existence and of full age, they can terminate the trust, subject to a discretion on the part of the court to say otherwise. The Court of Appeal and the Court of First Instance in Guernsey held that this didn't work in the same way as Saunders and Vautier, because if you had a list of beneficiaries with a power to add more, that the ones on the list at the moment could terminate the trust. So the fact that more could be added later didn't affect that, because they weren't beneficiaries within the meaning of the Act. They were simply potential beneficiaries. So that's, I think, opened a few eyes to an aspect of Guernsey law and Jersey law as well, because they have the same provision. And has caused some trustees of settlors to scratch their heads about whether or not they're running a risk that their trust might be terminated prematurely, where you've got a sort of placeholder beneficiary, and you're going to add beneficiaries later, whether you should be taking remedial action or even changing the proper law of the trust away from the Channel Islands altogether.
Yes. And what do you think trustees can do to protect them?
The Court of Appeal was anxious to stress this wasn't a sort of nightmare scenario. You could always add some more beneficiaries. You could add a class of beneficiaries. An open class of beneficiaries remains open for as long as there's a possibility of more beneficiaries being born into the class. So that's a way of keeping the class going. So there are remedial measures, but clearly trustees of some of these trusts are going to have to start thinking about what they're going to do.
Yeah.
Okay.
On to number 2, where we're off to the Hong Kong Court of Final Appeal. It's Zhang Hongli and DBS.
Yes.
It's a Hong Kong case about a Jersey law trust. The settlors in that case transferred the only share in a company called Wise Lords into a Jersey trust. The trustee contained very wide anti-Bartlett clauses, which included provisions relieving the trustee from any duty to be involved in the management of the company, from supervising its directors, or from obtaining any information about the company. In 2008, on the recommendation of the settlors, the company borrowed large amounts and invested in foreign currency, primarily the Australian dollar. When the global financial crisis hit, the Australian dollar depreciated. Wise Lords suffered significant losses, and the settlors sued the trustee. At first instance and in the Court of Appeal, it was held that the trustee had a high-level supervisory duty which could not be excluded. The case went to the Hong Kong Court of Final Appeal, where it actually settled after the hearing but before judgment. Judgment was handed down anyway, and the Hong Kong Court of Final Appeal confirmed that there was no high-level supervisory duty, and trustees' duties are going to be shaped by the trust instrument. Michael, I think it's safe to say that trustees all over the world breathed a collective sigh of relief.
I'm sure they did. I must say I have some sympathy with the approach of the lower court, because having anti-Bartlett clauses in relation to companies which are simply there to hold investments is just a way of the trustee abrogating responsibility for its duty to invest prudently.
Yes.
But I think, yes, you're absolutely right. The answer that the Court of Final Appeal eventually came up with was probably what people were expecting and for the most part hoping. So yeah, professional trustees can sleep easier as a result. No doubt about that. Right, okay, so we'll now skip from Hong Kong to Bermuda and Grandview PRTC and Wong. Grandview is a case about a family trust, simply for the benefit of family beneficiaries, but with a power to add any person as a beneficiary. And after a while, the trustees came to the view that the family was well off anyway and didn't need the money, so they added in the trustee of a family, essentially a purpose trust, a philanthropic purpose trust, and gave all the money to entity.
Yeah.
That upset one of the members of the family, who then sued and said, this can't be right. You have to exercise your power to add beneficiaries for the purpose for which the trust was created. There is a basic substratum of purpose here, which is to benefit the family. You can't just bring in someone extraneous from the family and give them all of the assets. At first instance, that succeeded, which was very interesting. The Chief Justice in Bermuda decided that there was an argument based on the substratum of the trust, relying on lots of the fraud on power cases, including pensions cases like the Pilot's decision and the recent BA pension scheme case. On appeal, the Court of Appeal in Bermuda said, no, that's not right. The trust deed means what it says. If a trust deed says you can add any person as a beneficiary, you can add any person as a beneficiary. You're not restricted by the original purpose of the trust from changing direction and adding in someone who might not originally have been part of the original intention as to who was to benefit. So again, an interesting case because of really what was decided at the first instance, and there is, I think, an appeal on foot, or attempted to be an appeal on foot to the Privy Council. If it gets there, it will be very interesting to see how.
Yes, absolutely. I have to say, I'm in two minds about this decision. I think if you're a settlor or a beneficiary and you suddenly have the entire fund distributed to a new beneficiary, you might have some sympathy with that. Which way do you think the Privy Council will jump?
I think they probably agree with the Court of Appeal, but it would be quite interesting if they didn't, because these kinds of wide powers are very common and are often exercised in a way which completely transforms the beneficial class from one class to another.
Yeah. Okay, number 4, we're back in England, Wales, in the Supreme Court with the Lettermarque and Children's Investment Fund Foundation case.
Is this a trust case?
Well, good question. I think it's been described by some of our colleagues as a pensions case. So if they're going to describe it as a pensions case, I think we can certainly say it's a trust case.
Well, that was our thinking, wasn't it? Yeah, we're going to.
Yeah. So in this case, there were 3 members of a charitable foundation who were all eligible to vote as to whether or not the foundation should make a grant to a new charity. 2 of the 3 members, the former husband and wife, agreed to abstain from voting, and the 3rd member surrendered his discretion to the court. At first instance, the Chancellor concluded that it was in the best interest of the foundation for the grant to be made and directed the member to vote in favour of it. It came to the Supreme Court. The Supreme Court said, firstly, that members of a charitable foundation are fiduciaries in relation to the charitable objects, but not in relation to the foundation itself. And second, because they were fiduciaries, they were subject to the control of the court. So in circumstances where the independent member had surrendered his discretion to the court could direct him how to vote. So I think the case might have some interesting ramifications for other fiduciaries like protectors, and in cases where a trustee power is subject to protector consent, and the possibility that if a trustee surrenders their discretion to the court, that the trustees could be directed how to exercise a power, and then a protector could also be bound by that, whether they surrender their discretion or whether it's because the court's found what's in the best interests. Yeah,
I mean, I'm not sure. Well, it is important because it does seem to suggest that a protector can surrender his discretion in the same way a trustee can. But whether a court would actually override a protector who wanted to take his own view, unless the court was of the view that no reasonable protector could disagree with what the court had decided. Which is
yes.
Okay, so that's interesting. And then the last one, this is the board,
yes.
This is the pleading case. This
is a pleading case. Scraping in at number 5, it's SOFA and the Swiss Independent Trustees. We don't need to go into the facts except to say it gives guidance about what you should do if you're pleading dishonest breach of trust. I think it shows that the courts are willing to be a bit forgiving where the dishonesty is to be inferred from a course of conduct, but really as a claimant you need to be as clear as possible when pleading fraud.
Yeah, I think the message is if you're pleading fraud, it's probably a case you should have a look at.
Yes.
Yeah. Okay, well that's the top 5 for the last year.
That's our top 5.